The second topic we are going to explore in this unit is the functions of comparative law. Before we get to these functions, we must first talk about comparative law and how it became a field of its own, how it became a science. Pause this video for a moment and read these few lines taken from The Politics, a book by Aristotle. After you have read these lines, in your opinion, why and how does Aristotle compare? We can compare for different reasons. We can compare for practical reasons. For example, if I'm a tourist looking to have a good time in a foreign country, I would want to know what is the drinking age there. If I want to marry a foreigner in a foreign country, I would like to know what is the legal marriage age, the legal age for marriage. If I'm an investor, I would like to know tax legislation, interest legislation. What would be my position as a creditor or as a debtor? In all these examples, what I'm doing is studying the foreign law. I'm only getting information about foreign law. Is it enough to consider this as comparative law? In other words, comparative law can be defined as a study or as a description of foreign law? No. It is important that at first we know the foreign law, that we describe foreign law before we compare it with our law. But comparative law is not just about description. Comparative law goes beyond description of foreign law. And that's why we consider it as a science of its own, because it leads us to analyze and evaluate and reflect upon law as a phenomenon. It gets us beyond the confined notion of positive law. So we can also compare for theoretical reasons. In the excerpt you just read from Aristotle, and the same was done by Socrates also, in Plato's Republic, they are comparing constitutions to determine which is the best form of government or to classify them. Aristotle compared between dozens of constitutions, actually 153 constitutions of city-states. Legal thinkers used to compare since ever. All legal thinkers and authors and lawyers compared. Aristotle, Socrates, Montesquieu, in his Esprit des Lois, also compared between legal systems and legal norms. However, scholarship considers that comparative law became a science, became a field, an autonomous field, in the late 19th century and at the beginning of the 20th century. At the end of the 19th century, we witnessed creation of many societies, associations that dealt with comparative law. Many universities created chairs specialized in comparative law. Many journals were published that were specialized also in comparative law. The culminating point was in 1900 in Paris' first International Congress of Comparative Law. Comparative law then was considered a field of its own, and not just a side activity done by legal thinkers while they were researching other aspects of law. It became a legitimate, autonomous field of research and law. According to René David and Geoffrey Spinoza, comparative law is threefold useful. First, it is useful in historical and philosophical research related to law. Hence, the first function which is a better understanding of law as a phenomenon. Then, comparative law is also useful for better knowledge and improvement of national laws. Hence, the second function, comparative law as an aid to the legislator. Finally, comparative law is useful to improve the legal system of international relations by harmonizing and unifying law. Hence, the third function, unification of laws.